Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. We're talking about good moral character, and I've done quite a few videos on this in regards to naturalization. So the question comes up, is there a limitation upon which the officer can ask to determine whether or not there is good moral character? Meaning, can the officer go beyond the statutory 5 or 3 year period? And in actuality, the officer can, but the officer cannot use that as the sole basis for a denial of naturalization because of good moral character. So, for example, if there was such a crime, 6 years ago or 7 years ago, and then nothing else has occurred since that time, the officer could use that as the basis to deny could not use that as the basis to deny the naturalization. But if there are events that have occurred during the statutory period and the officer inquires as to the past, then it is possible to incorporate the events, the crimes, the incidences, the admissions, and so forth that occurred way in the past in order to show that there's been no rehabilitation, that the events are continuing. We did a similar video to this, such as where someone had a DUI, and one DUI within the statutory period is no problem. But once the DUI, they look past the statutory period, this person had 10 DUIs plus other stuff, that was sufficient to deny the naturalization. So it is possible to look outside the window, but it has to be done properly. Okay, more on the coming videos.